again for another law of contract class. On today's class, we are talking about terms implied by statute. In my last class, I talked about terms implied by trade, and I told you the discrepancy between terms, implied terms and express terms. Do you understand? But in this class, we are talking about terms implied by statute. My previous set of classes on terms of a contract, we've talked about conditions and warranty, innominate or intermediate terms. We've talked about fundamental terms. We've talked about the difference between a term and a mere representation, and all those and all those. But in this particular class, we'll be talking about implied by statute. Before we do that, if this is your first time of coming to my channel, what's the problem? I don't. Is it better? So before we continue, sorry, NEPA have taken light, so it's the last battery on my ring light that I'm using. If you cannot relate, it means that you are probably not a Nigerian, or by extension not an African, because I think that this is an African problem. What's the problem? Doesn't make it worse. Yeah. Is it better?
I don't think I can really.
Yeah. Is it better? Okay, so as I was saying before, I was interrupted by the person who told me about the ring light and all that. So the thing is that there's no light right now, as you can see, so we are trying to get as much illumination as possible for our class. So with that, I think that is enough for that. Nigeria has happened to us in this class again, but we move regardless. We have to teach this class today. So we are talking about terms implied by statute, correct? Yes, we are talking about terms implied by statute, and I was trying to tell you things about the last set of classes relating to terms. Now, going straight into what we are talking about now. But before we do that, if this is your first time of coming to my channel, standing before you is Olayeni Diekolola Daniels, popularly known as Dieko Spectre, and this is another episode of Dieko Talks Law. Please don't forget to click the subscribe button as well as the notification bell, so that anytime I release a video of this nature, you'll be one of the first set of people to get notified and watch the video. So with that, we move into what we are talking about today, terms implied by statute. So let's go straight to our notes. You know that our modus operandi is that we go through the notes first, and then we go to our classes. So whilst we are going through our notes for today, if you don't have the note, a copy of the notes, you can just decide to jot things down from what I'll be teaching so far. So over a period, courts gradually accepted and enforced certain terms into contracts, mainly for the sales of goods, even though they were not expressly stipulated. This was done mainly to protect the weaker party, usually the buyers or consumers, in contracts for sales of goods. The Sales of Goods Act, passed by the British Parliament in 1893, was substantially a codification of the existing common law of sale. This part of the act, which is relevant to us at this stage, is the part containing implied terms. Section 12 up to section 15 of the Sales of Goods Act, contain these terms that are implied in all contracts for the sales of goods unless expressly excluded. except the parties say that, the act would not be binding on them, the provisions of the act will not be binding on them, it will not be binding. Do you understand? And all that. So the terms implied are as to title, to description, suitability for purpose, sample, and mercantile quality. Now, it should be noted that the Sales of Goods Act of 1893 applies in Nigeria directly as an English Statute of General Application enacted before 1900. However, the western region of Nigeria enacted its own Sales of Goods law in 1958. This was applicable to Osun, Ogun, Oyo, Ondo, Ekiti state of Nigeria until they enacted their individual Sales of Goods law. Also, Lagos and Bendel states have enacted their Sales of Goods laws. This means that the Sale of Goods of 1893 does not apply to these 7 states. The Sales of Goods Act of 1893 does not apply to these 7 states. However, since the term of their Sales of Goods law are virtually identical to the term of the English Act, the principle of law arising from the interpretation of the provisions of these laws are therefore uniformly applicable throughout the country. Now, this is what I'm saying. You know that in my last class, I told you that there's something called implied terms, right? Terms that the parties did not expressly contemplate, but are implied into the contract. In the last class, we're talking about implied terms as to what? As to trade. And when we talked about it, I gave you certain things to look at. As the persons written the term, has it been expressly agreed by the parties? If it has, then you cannot imply into the contract, because the express term will always prevail over the implied term. Secondly, did they exclude the applicability of implied term by trade from their contract? Because if they do that, then that cannot be binding. Also, is the implied term so notorious? Is it so notorious and well established that the both parties are presumed to know? They in fact know or are presumed to know. And lastly, does that implied term agree with the tenor of the document? Those are the things I told you in my last class. In this class, we are talking about implied term as to statute. And because what we are talking about here is statute, which means a law. So what are the implied terms that have been written down in a law through which, even though the parties have not agreed, but because that law is in operation, the provisions of the law that talks about certain implied terms would apply and be binding on the parties, except the parties have excluded the applicability of the law from their contract. Do you understand? Because this law is in force, whatever the law says will be binding on the parties, except the parties, while they are making their contract, say expressly that the provisions of the Sales of Goods Act, which is the law that we are talking about, the provisions of the Sales of Goods Act will not be binding in our contract. If the parties do not say that, then the provisions of Sales of Goods Act would be binding in the contract. Do you understand? Now, once we've known that, we are talking about Sales of Goods Act of 1893. Sales of Goods Act of 1893, about, if I'm correct with my maths, over 100 years ago that this law was created in England. Do you understand? The law is applicable to all of Nigeria, because it is part of what we know as Statute of General Application. I told you in my last set of classes, I told you that when a statute was in force in England before January 1st, 1900, all the statutes enforced in England are automatically enforced in Nigeria, except that statute has been repealed in Nigeria, or a new law has been made to, take away the efficacy of the English law. Do you understand? So in Nigeria right now, we have certain statutes that has been made on this Sales of Goods Act, and that was the Sales of Goods Act of Western Nigeria. Western Nigeria, let me give you an example of what I'm talking about. Now, this is the whole of Nigeria, right? So we have, let's say, where is west? This is east, so this is west, right? So these parts of Nigeria have their own Sales of Goods law of Western Nigeria. The other part of Nigeria, this other part, we all practice Sales of Goods Act of 1893. Do you understand? So when we are looking at this part alone, what are the states in this part? You have Oyo, Ondo, Ogun, Ekiti. You know those states that I mentioned earlier, Lagos and Bendel, they have their own. First, they were under the statute of under the Sales of Goods Act of Western Nigeria, before they then decided to have their own individual Sales of Goods Act. Lagos has its own individual Sales of Goods Act and all that. But you should know that Sales of Goods Act that's the general one of England, 1893, is binding on every part in Nigeria except just the few states. I don't think they are up to 10. Just the few states, and we have 36 states in Nigeria. So it's binding on all the few states that have decided to have their own state Sales of Goods Act. Now, the reason why we are studying the Sales of Goods Act of 1893 is because, you know, the provisions are the same. They just lifted it from the Sales of Goods Act, dumped it on their own Sales of Goods law. No ingenuity, no research, no nothing. Just carry it like this, dump it there. So if it is the same in terms of the substance, so why don't we just learn this instead of the fact that the only thing that is different is what may be section 12 here can be section 14 here in a Lagos state law, and can be section 13 in Ogun state law, or maybe section something. Do you understand? Which might differ in these laws. But the substance, if we say condition as to title section 12, right? If we look at condition as to title in Ogun state of goods law, it might probably be in section 15 as opposed to section 12. But what is the substance of that section 15? Condition as to title. What is the substance here too? Condition as to title. So it's the same thing. Do you understand? So basically, we'll be learning that of Sales of Goods Act, which might differ in section with these laws, but are still the same substance. Do you understand that? So with that, that's the preliminary part of our class for today. So let's go to the first one that we'll be learning. The first thing we'll be learning would be the implied condition as to title, like I said earlier. Condition as to title. Implied condition as to title. By section 12 of the Act, in any contract of sales of goods, there is an implied condition on the part of the seller that in the case of a sale, he has the right to sell the goods, and in the case of an agreement to sell, he will have the right to sell the goods at the time when the property is to pass. The seller is also deemed to give an implied warranty that the buyer will enjoy shall enjoy quiet possession of the goods and enjoy warranty that the goods are free from any charge or encumbrance in favor of the third party. So what are we saying here? We are saying three things, right? Number one, when the seller wants to sell the goods to the buyer, and the buyer wants to buy the goods from the seller, there is an implied condition, not a warranty. You know, I've taught you in my class, I've taught you what is a condition and a warranty, right? A condition, you can repudiate. A warranty, you can sue for damages. Now, the first thing that we are going to learn under the implied condition as to title is that if I want to buy a phone from somebody, let's say from you that you are watching, if I want to buy a phone from you, there is a condition which we might not have envisaged in the express terms of the contract, but there is a condition that you yourself, the title vests upon you, and you can give me the phone. In law, when they say title is the ability to own a thing. Do you understand? If I have title to land, this means I own the land. Title is ownership in law. Do you understand? So if I want to buy a phone from you, and the question that should arise, it shouldn't even arise, because you already put yourself out to me that you are the owner of the phone for you to want to gain now. Do you understand? So it is because of that we have this section 12 that talks about a condition. So by the time I want to buy the phone from you, do you understand? There is a condition that you have the title to the property and you can sell that property to me. The phone, the goods, the whatever I'm buying from you. There is what? There is a condition that you have it, right? Now, that is at the time when I want to get it from you. There is also something known as an agreement to sell. I am not buying it currently, but as at the time where I want to get it from you, where the what is it called, contract is to be concluded, that at that time you will still have the title to the land. So let us say that in January I contacted you that I wanted to buy a land, and you say, you have one land like that in a place, let's say plot A, the name of the place is plot A, and the owner of the land in plot A, and then you told me, I have a land at plot A and all that and all that, and I said, don't worry, I'll buy it in March. So there's an agreement to buy the land from you, right? And you have an agreement to sell the land to me. So the time that is operative is not when you were telling me in January. The time that is operative is when you are to sell it in March. As at the time you are about to sell it in March to me, did you have title to the land? Did you understand? You know, the first one is outright sale. Where there is an outright sale, as at the time you are giving me the property and I'm giving you the money, do you have the title to the land? And where there is an agreement to sell, it is not the time where we are making the agreement. It is the time when the actual sale is to be carried out. By the time when the actual sale is to be carried out, did you have the property at that point? So if we had the agreement to sell in January, but the actual sale is to be carried out in March, did you have the actual sale, the actual title to that property by March? Did you understand? If you do not have it, then there is a breach of a condition as to title. Do you understand that? So let's go back to our notes. So, like I said, section 12, in any contract for sales of goods, there is an implied condition on the part of the seller that in the case of sale, he has the right to sell the goods, right? And in the case of an agreement to sell, he will have the right to sell the goods at the time when the property is to pass, right? Now, the seller is also deemed to give an implied warranty. Now, this is not a condition. This is an implied warranty that the buyer shall enjoy quiet possession of the property, and another warranty that the goods are free from any charge or encumbrance in favor of a third party. So, what we are saying now is that when we have two conditions, that's condition rule and two warranty rule. The first one is outright selling. The person has the title of the land. The second one is when there's an agreement to sell. The person as well, at the point where he's to sell, has the title to the land. Now, those are on conditions. Now, we now have that on warranty. The first rule on warranty is that I'm going to enjoy quiet possession of the property. If I come to buy something from you, and then by the time I get home, somebody's telling me, no, my phone be this, my phone be this, no, my phone be this, my phone be this, and all that, and I bought it from you, I cannot sue you and say that I'm repudiating the contracts because it is not a condition. I can only sue you and collect damages. Why? Because you have breached the warranty in section 12, the warranty that gives me the ability to enjoy quiet possession of my property. I bought phone from you, and since I got home, the guy came to meet me and he's telling me that what is his phone? It's not his phone. It's his phone. You know, we are not arguing, but I buy it from this guy now, and my phone didn't give you. You know, all those kind of things and stuff. So, and then the last one is the last warranty is when the goods are free from charge or encumbrances. Now, we are going to look at these rules in the light of cases. Now, thus, a seller who has no title, the first one that I told you, when he wants to sell it to you, if he has no title, then he's in breach. We have the first case of Akoshile versus Ogidon. Akoshile versus Ogidon. The defendant, who had earlier bought a car from a European for £335, sold it to the plaintiff for £340. Subsequently, the European was convicted for stealing the car, and the latter was therefore removed from the plaintiff's possession. That is, the car was removed from the plaintiff's possession by the police. Just to understand what is going on here, the person here, the defendant, bought a car from who? From an European who came to Nigeria. And then we bought the car normal, and then they arrested the European for stealing the car. Do you understand? So they cannot arrest the new guy, the guy that bought the car. Why? Because he didn't know what was going on. but and by the time they arrested that European, the person who bought the car from the European had already sold it to what is it called? Had sold it to a third party. The rule in operation here is nemo dat quod non habit. You cannot give what you don't have. If you don't have a title in yourself, you cannot give another person a title. So let's say we have the European here, right? Then we have the defendant. The European sold the car to the defendant, and the defendant sold the car to the plaintiff, right? To E to D, D to P, right? And then now this European, we now realize that the European did not have title. If the European did not have title, can D have title? No, because the European stole the car. So if the European is not the owner of the car well enough to have title, you cannot give what you don't have. He did not have title. He couldn't have given title to the defendant. Because the defendant did not have title, the defendant could not have given title to the plaintiff. And because the plaintiff had title, because the plaintiff didn't have title, then the police came to collect the car from the plaintiff. Then the plaintiff then sued the defendant that you did not have title to the land or to the car when you sold the car to me. And therefore, that's a breach of a condition. What did the court say? There was something that the defendant did there that made me just wonder how sometimes lawyers argue. And then the argument that the defendant gave was that of caveat emptor. Caveat emptor. I know that as a contract law student, you might not know what caveat emptor is. Caveat emptor is used in two circumstances. The first one is used in land. And when it is used in land, it's called buyers beware. Buyers beware. You know, when you are going on the road and then you see beware of 419, this house is not for sale. That is a caveat emptor in land law. When it is used in land law, it is telling you that if you want to buy this land, be sure to investigate the ownership of the land. But when you are using caveat emptor in land, that is when we are looking at know who is the owner, know who, if there are encumbrances to the land. Caveat emptor operates in relation to land law in that manner. So he wanted to bring the caveat emptor operating in land law to goods that are, since the plaintiff was buying from the defendant, it was the duty of the plaintiff to have investigated the title of the defendant. The court said you don't even apply caveat emptor in that manner when it comes to sales of goods. In relation to sales of goods, I will teach you in subsequent classes or in subsequent this thing. When you are talking about caveat emptor, we will talk about it in another manner. You don't talk about it in a manner of ownership to title. Do you understand? But I don't want to talk about it now until we get to the part where we are supposed to talk about it. So, however, the defense was rejected. That's the defense of caveat emptor. What was the argument of the defendant? The argument was that the plaintiff should have investigated the title. If the plaintiff had investigated the title, then he would have known that D in fact did not have the title because E, the European, stole the car. The court held. Look at what the court held said. The court said, however, the defense was rejected as being inapplicable. This is what I'm talking about. And the plaintiff was held to be entitled to the refund sought. According to Rhys J, Rhys J said that the doctrine of caveat emptor, it seems to me, has no application in the present case since it relates to merchantability of goods sold. Can you see that? When you are talking about caveat emptor, it relates to merchantability of goods sold in relation to sales of goods. When you are talking about caveat emptor in relation to land, that's when it relates to ownership of land and you doing due diligence to investigate the owner of that building that you're about to buy. Land law, caveat emptor defense is different. Sales of goods, caveat emptor defense is based on the merchantability of the goods. It is not based on the ownership. So this is something that I believe that a lawyer should know before you raise the defense in court. It's just like you raise the defense without even knowing the defense that you are raising. You didn't make your research on how to use the defense. You are using a defense on merchantability of goods for ownership in relation to sales of car when it's not sales of land. If it were sales of land, it would have been a valid defense. So far, he is able to prove the element of caveat emptor. Do you understand? So we move on. It says that the doctrine of caveat emptor, it seems to me, has no application in the present case since it relates to merchantability of goods sold. Here, there is no question of the motor car being fit for purpose. You see, when you are talking about caveat we are talking about it being fit for purpose and for which it was sold. The plaintiff claim is that the defendant sold the car which he had no title to sell and consequently had no title to convey to the plaintiff. It is not disputed that the sales of goods is applicable, and in the view of the decision of the judges in Roland versus Duval, this is a very important case to cite when we are talking about implied condition as a title. Roland, ROLAND versus Duval, DIVAL. Roland and Duval, it does not seem to me to admit any argument that the plaintiff is not entitled to recover damages for the price paid for the to the defendant. So I told you, right, that when we are talking about the condition, a breach of a condition does what? It entitles the other party to repudiate and collect his money. And what did he do here? He said, you don't have a title to the car. Oh yeah, I want to repudiate this contract. No more contract, give me my money. Not only did he even collect his money back, he sought for damages, because a breach of a condition gives the innocent party the ability to seek for damages in the event of the breach of the condition, and also to see the contract as repudiated. And the plaintiff exercises right effectively in the case of what's the name of this case? Aki something. Akoshile versus Ogidon. Do you understand that? And then in Akoshile versus Ogidon, the court referred us to a very important case of Roland and Duval. Now, the earlier case of Roland and Duval referred to in this judgment was similar, both in fact and in decision to that judgment. Also, if you look at the case of Niblet versus Confectioners Materials, Niblet is spelled Niblet versus Confectioners, Tioners Materials, Materials. Now, in this case, the breach of the condition as to title was extended to cover a situation in which the purchaser of goods was prevented from reselling them as a result of successful action brought against the seller by a third party for the infringement of a trademark. Now, for you who do not understand, let me take it again. A breach of a condition as to title was extended to cover a situation where the purchaser of goods was prevented from reselling the goods as a result of a successful action brought against him by the seller against the seller by the third party. So we have goods that has already been sold to a buyer. So now went to court to tell that buyer to not resell the goods. Why? Because the seller who sold the goods to the buyer had a case that has been won against him. Can you see? So it means that the buyer, the seller himself, let me, this is seller, this is buyer, then this is third party. The seller sold the goods to the buyer, and then the buyer wants to sell it to P, and then third party now came to B, who bought the goods from the seller, and told B that there is an injunction from court to stop you from selling it to P. Imagine I buy a phone from somebody, me and buyer, I buy a phone from somebody and I want to sell it to another person. One person that came to carry court injunction and meet me now, no, I cannot sell my phone that I use my money to buy. If I can't sell it to somebody else, that no, I can't sell the phone. Then what do? I go to meet the seller, and then I realize that the seller in fact did not have title to the land and to the property, and then I sue for what? Breach of condition as to title. It is because the seller did not have title. Who had title? T. It's because the seller did not have title. T had title. That's why T can stop me from selling it to P. So my problem is not with T. Me and T, we don't have issues. Me and the seller gangan issues. These are the people that have issues. Me and T, I cannot come and meet T. I don't know you. Where did they come from? Come off my phone, because you know that they did not have any transaction. When T came and said, oh, I'm stopping you. Do you understand? So you cannot tell T, I don't know you. Who you go back to meet is the seller. Seller, they say you don't get title. Why? And then you go to court and go and collect. Not only will you repudiate the contract, you would also collect damages for not having title to the land. And what is the case that we are talking about? Niblet versus Confectioners Material. Now, we are done with the first thing when it comes to implied terms as to statute. We are done with the first thing. What's the first thing? We are talking about implied condition as to title. So the second thing that we are talking about is sale description, and that's the last thing we'll be talking about in our class for today. In our next class, we'll be talking about more implied term as to statute. So let's go to B, sales description. So when we are talking about sales description, we are talking about section 13. So section 12 is on what? Implied terms as to title. When you are in your exam hall and you are writing exam and then there is a question on this issue, when you want to get your full marks, the first thing that you must cite when you see a section, when you are answering a question based on a section, you are answering a question on conditions and blah blah blah, you must first cite the section that you are bringing your authority from, which is section 12. If you don't cite section 12 and you are citing a Akoshi whatever and Ogidon, and you are citing Roland and Duval, you are citing Nippet and confessional material and all that, if you are citing those cases but you don't cite the section, you will not get your full marks. And when you are answering this question, you also have to bring some cases, condition inherent and all that. The cases on condition inherent, what are the cases? I think Bettany and Guy and Poussard versus Spears, right? Spears and Pond. Why are you bringing the cases? To tell us the effect of the breach of a condition. Do you understand? The cases tells us the effect. You also need to tell us section 11 subsection 1 of Sales of Goods Act that tells us, the effect of breaching a condition. Bringing those things together gives you your full mark when you are answering questions like this. Because if it was a breach of warranty, you know that under this we have conditions and warranty. The first one is on the title. The second one is on warranty as to freedom from encumbrances and you having quiet possession. Do you understand? That is a warranty. A breach of warranty of your quiet possession does not give you the authority to repudiate. What is your authority for that? You go and look for section 11 that talks about what a condition is, what a warranty is, and bring your cases to support it. Do you understand? So if it's breach of a warranty, according to section 12, quiet possession and encumbrances, use warranty. If it's according to title, which is still in the same section 12, don't forget that there are two things embedded in section 12: quiet possession and encumbrances, and condition to title. These are things embedded. One is condition, one is warranty. So if you are coming under section 12, you have to tell us which one are you talking about. Then you give us the repercussion of breaching it and all that. So while you are citing the cases of section 12, cite that of condition or that of warranty before you give your total submission. And then we go to section 13. Section 13 is what? Sales by description. Now, by section 13 of the Sales of Goods Act, when goods are sold by description, there is an implied condition that they shall correspond with the description, and if the sale is by sample as well as by description, they must still correspond with the description as well as by sample. So this is what they are saying. You want to go and buy something and then you are meeting somebody who is, so to say, an expert in something, or please, I want to buy something, this is how it looks, that is how it looks, this is how it looks. Do you understand? You are describing it for the person. If the person is bringing the thing, then that thing that the person is bringing must be something that you must have described to the person. That's what section 13 is saying. And if it is accompanied with a sample, so which means that the person gave you a sample, that is this what you are talking about when in your description? Yes, this is what I'm talking about. When the person is bringing the main thing, the original, the first thing that the person gave you was just a sample. The original thing must also be just like that sample. It must match your description and match your sample. So let us go with the note again. By section 13 of the Sales of Goods, when goods are sold by what? Description, because that's what we're talking about. Sales by description. When goods are sold by description, there is an implied condition. This is not a warranty, this is a condition. There is an implied condition that they shall correspond with the description. If I'm buying something from you based on the description that I gave to you, there is a condition that if you do not listen to what I described to you, and you brought a goods that is not the same as what I have described, then there is a condition that you have breached, and I can sue to repudiate and seek for damages. And if the sale is by sample as well as by description, they must correspond with the description as well as the sample. Usually, the condition applies where the buyer has not seen the goods and relies on the seller's description. So, for example, if we look at the case of Valet versus Whip, VARLEY, Valet versus Whip, WHIPP. An old reaping machine was described by the seller as new, and then the buyer who relied on the description and bought the machine without seeing it was allowed to rescind the contract and recover his money. So he had an old machine, and then he went to the shop. He wants to buy one old reaping machine. He went to the shop and said, this is what I want to buy. The guy said, now reaping machine, now I know that's what I deal in. Oh, I want a new one. No problem. It's not a new one that you want, no problem. And then he went to go and bring, let's say 2 days later, he brought the reaping machine. And then is this still new or old? He said, nah, this is new. And then when he got home and looked at it very well, he now saw that, this thing is an old reaping machine. Then he brought it back. And then he said, no, you cannot collect it. You don't carry him. Went to court. What did the court say? Because he relied upon what he has said, that's sale by description. The person said that it was new, and then he relied on it that it was new. He relied on him in relation to what he wanted, a reaping machine, a new one. He relied on what he has said. Because of that, he has the ability to repudiate the contract when what he is buying is different in terms of description from what he described to the seller. He described to the seller that he wants a new reaping machine. The seller knew he wanted a new reaping machine, but gave him an old reaping machine. The court held that he can repudiate the contract based on the fact that that was a breach of a condition. Now we move. Nevertheless, even when the purchaser has seen the goods, if he still relies on the seller's description to buy, the condition will still apply. This usually occurs where the description of the goods require technical knowledge or where the material facts relevant to the description are peculiarly within the seller's knowledge. Now, if we look at the case of Bale versus Taylor, Bale, BEALE versus Taylor, TAYLOR. A car sold by the defendants to the plaintiff, which was described as a 1961 Triumph Herald, turned out in fact to be the front of a 1948 Triumph Herald welded to the rear of a 1961 model. Although the plaintiff saw the car before the sale, he was allowed to rescind the contract for breach of the condition. So what are we saying here? We are talking about a party, that's the seller. He was told by the buyer, what do you want? I want so. Even if he had seen that so that he said that he wanted. So, okay, for example, I say I want to buy an iPhone 12. You know that there is no big difference between iPhone 12, iPhone 13, and iPhone 14. So, because the camera at the back, they are usually 3. You have to know those phones for you to understand, what we are talking about. So, I said I wanted to buy an iPhone 12, and I went to the phone dealer. I said I want to buy an iPhone 14. Yeah, let me not say iPhone 12. I wanted to buy an iPhone 14. And then he gave me an iPhone 12. I saw it and I asked him, is this iPhone 14? He said yes. But he was giving me iPhone 12. When I got my friend saw that, you said you wanted to buy iPhone 14. Why do you buy iPhone 12? And I told them, no, it's iPhone 14 I bought. And then I went back and then he said, no, he has already sold it. Now, what this rule is telling us is, even if the buyer was seeing it, so far it does not match the description that the buyer was saying. Why? Because the buyer did not have as much knowledge as the seller has. Do you understand? Because the buyer did not have as much knowledge as the seller has, the seller is supposed to lead the buyer through, where the seller knows that the description which the buyer is giving is different from that which the seller is giving, and he wants to rely on the fact that the buyer was seeing it. The court said even if the buyer is seeing it, so far it is the different description, that it will still apply. Let us look at what the court, the rule, and what the court held again. The rule is that nevertheless, even where the purchaser has seen the goods, if he still relies on the seller's description to buy, even when I saw the iPhone 12, but I relied on the seller description that this is iPhone 14, the condition will still apply. This usually occurs when the description of the goods require technical knowledge, or where the material facts relevant to the description are peculiarly within the seller's knowledge. So I will not know the difference between 14 and 15 and 12. It's somebody that is, a phone savvy person that will know the description. And so when I meet you, I am asking, this is what I want. I don't know the description. I don't know the difference. I know there are 3 cameras, and I know that there is Pro, Pro Max, Pro, all this, understand. So I don't know which one, but this is what I want. I'm telling you, this is what I want. You knew what I was asking for was iPhone 13, but you know that it is very iPhone 14, but you know that it is very similar to iPhone 12, and you are then giving me iPhone 12 because I was seeing it. You were relying on the fact that she been waiting. I give you, you see am. Because I was seeing it, you were relying on that fact. The court held that no. The court will hold that no. My description will supersede my seeing, even when because especially because this knowledge is within the technical know-how of the person selling. And I gave you the case of Bale and Taylor, where a car was sold to the defendant, was sold to by the defendant to the plaintiff, which he said he wanted a 1961 Triumph Hellroute. That is a car model, but he does not know the difference between 1961 and 1948. But he was telling him, what I want is 1961 Triumph model, and then he was sold a 1948 Triumph model. Even though the plaintiff saw the car before the sale, the court held that he could still rescind the contract. I hope you understand that. Now, also, if we look at the case of Ogu versus Leventis Motors, where the appellant contracted to buy a year-old second-hand number BYA 648. He was given a 4-year-old second-hand lorry with registration number BYA 648 attached to it. He wanted to buy a particular lorry, which is what is it called? 1-year-old second-hand lorry. That's what he wanted to buy. So he was asking him, is this the 1-year-old second? Do you understand? And then he knew that what he wanted to ask, that's the seller, knew that what he wanted to buy was the 1-year-old second-hand lorry, but still sold him a 4-year-old second-hand lorry. And on discovering the error that the lorry had broken down on several locations, the purchaser was allowed to return the lorry and say, no, this is not what I said I wanted to buy. This is sale by description. When you describe to the seller, this is what I want to buy, section 13 of the Sales of Goods Act. Seller, this is what I want to buy, and the seller gives you something different from what you are buying, you can rescind it because there is a breach of condition. We've seen the case of Ogu and Leventis, we've seen the case of Bale and Taylor, we've also seen the case of Valley and Whip. And let's get to our last case of Boshali versus Allied Commercial Exporters Limited. What's the rule in Boshali versus Allied Commercial Exporters Limited? Where in a sale by description, a sample of the goods is provided, the sample could be regarded as a description of the bulk of the goods. So this is what I was telling you earlier. If I want to buy something and I'm describing that thing to you, and you then give me a sample, this happens when you want to buy cotton, or you want to buy, I think it happens more in cotton. When you're outside and you're like, which one do you have? They can't be carrying all the cotton up and down. So they just give you sample cottons, and then you saw one that you liked. Do you understand? You saw the texture. There is a part where they also cut part of the cotton for you, so you feel just that part of the cotton. And then he felt it, and he was like, no, this I like this quality, this is what I wanted. And he paid money for the bulk of it, and then what they brought to him was of low quality, so low that he said, no, I'm going to return. He said, no be waiting you touch me. He said, no, there are two different things. And then the court will hold that this is the rule. Where there is a sale by description, a sample of goods is provided, regarded as a description of the bulk. This is what I described to you that I want. You must give me from that bulk that you are giving me, the one that I paid for, you must give me same as this sample that I saw. Do you understand? And that was what was held in the case of Boshali versus Allied Commercial Exporters Limited. The appellant in Nigeria contracted to buy cloth materials from the respondent in England, although it was a contract of sale by description. Now, the material which they wanted was a 36-inch dyed crepe quality AS 1000 grey cloth origin. In short, the name alone is just a lot. What they wanted to buy, this is the material. The material is 36-inch dyed crepe quality, AS 1000 gray clothes foreign origin. That's what they wanted to buy. And then the description was followed by a sample labeled and identified as the goods described earlier. So when they saw the name, they said, yes, this is the name of what we want to buy. But not only did they even give them the name, they also saw a sample that they could touch, and they said, yes, this is the sample of what we want to buy. Now, when subsequently a sample taken from the bulk actually shipped was found to be inferior than the first sample, it was held that it constituted a breach of the condition as to description. The first sample was regarded as evidence of the description of the goods. Do you understand that? So they know the name of what they want to buy, and then they felt the texture, the sample of what they wanted to buy, and then by the time they ordered it and it came, they shipped it down, then they saw these are two different things. The court held, yes, you can rescind it because it is inferior and it does not match sale by description. So we've looked at section 12 of the I wanted to say Evidence Act. We've looked at section 12 of the Sales of Goods Act when it talks about condition as to title, and we told you that there are conditions as to title as well as warranty as to quiet possession and free from encumbrance under section 12. And sale by description is section 13 of the Sales of Goods Act, and I've discussed to you through cases that where you tell somebody this is what you want to buy, and what that person brings is a different caliber from what you told the person that you wanted to buy, then the court is more likely to say no to that kind of transaction. Do you understand? So with that, I think this is where we are going to end our class for today. How many minutes? 46 minutes. How many people? And is there any question? Okay, so I'm going to give you about another 30 seconds for questions. If there are no questions, then I'm going to end the class for today. We are going to continue our class on implied terms of contract from tomorrow. Being Saturday, we'll continue our classes from tomorrow. But for today, this is going to be the end of the class. So is there any question before I call it a day for today? Okay, so great. In the absence of any question, then thank you so much for watching to the end of the lecture. I really, really hope that you understand everything that we've taught so far today. The next class, we are going to be talking about fitness for purpose and merchantability of a good and all that. Well, those are things that we'll be talking about in our next class. Before we get to our last class, we'll be talking about implied term by the court, and all that. But I hope that I finish all my classes on implied terms before, and that obviously would mean finishing all my classes on terms of a contract. So I hope to see you in other sets of classes as well. Have a very beautiful day.